Hi drivers, Paul Taylor from Truckers Justice Center. We are a law firm that handles employment-related claims and owner-operator disputes between truck drivers and trucking companies. It doesn't have to be just a trucking company. It may be a private carrier as well. So I've been talking recently on a lot of these videos about significant cases that truck drivers should know about. So I want to talk right now about a case called Skinner versus Brotherhood of Railway Labor Executives. This is the granddaddy of all the cases on controlled substance and alcohol testing. And it impacts you. It's a case that the Supreme Court decided more than 30 years ago. So in the George H. Reagan administration and George H.W. Bush administration, there were a series of proposals to require random testing, pre-employment testing, and post-accident testing of transportation-related workers. And so the DOT, through the Federal Railway Administration and through and then other agencies, such as what became the FMCSA, proposed nationwide transportation testing, transportation employee testing. Pilots, flight attendants, truck drivers, locomotive engineers, conductors on railroads. And all the regulations were basically the same. And today you can find that at 49 CFR Part 40. There are some separate ones for truck drivers and locomotive people, but 49 CFR Part 40 sets forth the regulations applicable to various industries that involve transportation. And there were several issues in Skinner versus Brotherhood of Railway Labor Executives. And the case made its way through the Supreme Court. There was a challenge by the Brotherhood of Railway Labor Executives saying that this violates the Fourth Amendment because it is an unreasonable search and seizure. Unreasonable to search somebody's bodily fluids, essentially, is what the argument was. And the defense was, in this case, at the Supreme Court from the government is, well, the Fourth Amendment, which prohibits unreasonable searches and seizures, prohibits that by government. Initially, the federal government expanded under what's known as the exclusionary rule, which extended the scope of what constitutes an unreasonable search and seizure. Supreme Court cases decided that, a case called Mapp versus Ohio. But we're talking about Skinner here. It prohibits unreasonable searches and seizures by the government. So the first issue in Skinner to be addressed by the Supreme Court was whether or not there was state action. And the federal government, the FMCSA's predecessors, the Department of Transportation, Sam Skinner was the labor secretary, the DOT secretary in the Republican presidential administration. So essentially you sue the head of the agency or the head of the department when you're in their official capacity, when you're challenging a regulation. So Labor Department, you would sue Martin Walsh, Secretary of Labor, who's Biden's Secretary of Labor. But in this case, the suit was nominally against Sam Skinner, the Secretary of Transportation. And the Department of Transportation told the Supreme Court, well, first of all, this suit should be thrown out. The regulations are valid because there's no state action here. It is compelling employers to do testing. And the Supreme Court unanimously, I believe, said, well, there is state action here because it's simply a government mandate for these searches, these urine tests, these post-accident tests, these random tests, these pre-employment tests. It's merely using the employers as the instrument of the federal government. So the Supreme Court said, yes, there is state action, and you need that essentially to challenge search and seizures. It has to be state action. The employers can basically search all they want, but here there's state action. And the Supreme Court was unanimous on that in the Skinner case. But the most important question was, does it violate the Fourth Amendment to the Constitution to require employees to submit to random testing, pre-employment testing, things of that nature? And a split Supreme Court, 7-2, said it does not violate the Fourth Amendment. And here's what they said. Drugs are a problem in the transportation industries. Mind you, this was a railroad case. So they said it's a problem in railroading. It's a big problem. And they said, well, the drivers, in this case, the locomotive folks, operators, the trainmen, the locomotive operators, the conductors, they're in an industry that has a drug and alcohol problem. Therefore, it's really important. And when you put something into the stream of commerce or operating on the railroads, in the case of motor carriers too here, operating on the highways, you have a lower expectation of privacy. And therefore, we're going to allow these regulations. There's a problem, and you have a lower expectation of privacy, and therefore we're going to uphold these intrusions by the federal government. And it was a 7-2 vote to uphold those in railroading, and basically the courts of appeals, who are bound by Supreme Court precedent, followed those in the cases of truck drivers. That because you're a driver, because drugs and alcohol were a problem back then, you essentially give up that right to privacy. You have a lower expectation of privacy when you're operating in the stream of interstate transportation. Now, the dissenters in the case were Thurgood Marshall, who was appointed by Lyndon Johnson, the first black justice on the Supreme Court, and William Brennan, who was appointed by President Eisenhower. So essentially the two liberal giants of the Supreme Court said, well, there may be a drug and alcohol problem in railroading, and by analogy, trucking, back in the 80s, late 80s, and it may make the roads unsafer not to test, but that's the price we pay for a free society. And I agree with them. I think the drug and alcohol testing regulations that have very little checks and balances, and the Supreme Court in the majority decision in Skinner said, well, there's enough protections here because there's an MRO who has to confirm a test, and there's chain of custody. To me, that's all bunk. We get calls every day where MROs don't talk to drivers, medical review officers, where the sample is not sealed in the presence of the individual. There's so much abuse in drug and alcohol testing policy, but essentially the Supreme Court says Taylor and Lavoie, doing business as the Truckers Justice Center, can do nothing. I don't think the Supreme Court was correct, but we live with precedent in this country. You do essentially, as a truck driver, check your rights as under the Fourth Amendment against unreasonable searches and seizures when you become a truck driver, at least in respect. This problem could have been taken care of by insurance companies mandating it and not creating this big apparatus of MROs, DERs, collection sites, all subject to abusing drivers. But this is a case you should know about. No time to challenge, really essentially no constitutional challenge to the FMCSA drug and alcohol testing regulations because of the case of Skinner versus International Brotherhood of Railway Labor Executives. 7-2 decision. It's settled precedent. You have fewer rights as truck drivers. than other people do when it comes to controlled substance and alcohol testing. It's unfortunate, but that's the law. Thanks for watching.